Hello, everyone. Welcome to another episode of Evershed Sutherland Podcast, Global Guide to Freezing Orders. This is Kiko Carrion, partner in the litigation department of Evershed Sutherland Madrid office. And I am here with Eduardo Buitron. How are you, Edu?
Hi, Kiko. Hi, everyone. I'm all right. Thank you.
Eduardo is a legal director in the litigation department of Evershed Sutherland Madrid office. And also, here with us in the studio, we have our colleague, Paco Lopez, a lawyer in our same department at the Madrid office as well.
Hello, Kiko. Hi, how's it going?
All good. Thanks for asking, Paco. Now, would you please be so kind as to tell our listeners why we are here today?
Sure. Well, as some of the people listening may already know, Global Guide to Freezing Orders is a podcast produced by Evershed Sutherland, a global firm that helps its clients to thrive at which us three work. In this podcast, each Evershed Sutherland office across the globe analyzes freezing orders in the jurisdiction. So today we're going to be talking about freezing orders in Spain.
That is great. So I think we should start by saying that freezing orders do exist in Spanish law and are somewhat commonplace in civil and criminal procedural practice.
Yes, Kiko. Although today we'll be focusing on freezing orders in civil procedural practice, I think our listeners need to know that freezing orders are also provided for in the Spanish criminal procedure laws. They have a special relevance in relation to white-collar crimes, and often they are a tool used by courts with the intent of either securing a potential sentencing consisting in a fine or impeding the defendant to conceal evidence for the trial.
Yes, Paco and Kiko. And in Spanish civil procedural practice, freezing orders are a type of interim injunction intended to prevent the disposal of assets by a party, called the corresponding party, that could potentially be sentenced in a future judgment. Their goal is to secure that potential judgment. The orders are granted for the benefit and at the request of the applicant party, and they are frequently in both court and arbitration procedures.
Right. I find this interesting. In Spain, freezing orders can be granted both by judges and arbitrators, although under slightly different rule. Is that correct, Paco?
Absolutely, Kiko. Freezing orders can be granted in arbitration proceedings as long as the parties to an arbitration clause have not expressly agreed to exclude this possibility. The main difference with freezing orders granted by a court is that arbitrators have no jurisdiction to enforce the orders, so court intervention is ultimately needed in any case. Other than that, freezing orders granted by an arbitrator are subject to the same rules and requisites as those granted by a court.
I believe, Kiko and Paco, that here it is important to know that not all assets of the respondent party can be frozen by means of these orders. As with all other interim injunctions, the Spanish procedural law sets a list of unseizable assets, amongst which are, for instance, house furniture or fat stuffs, and other more strict examples like pets or voting rights.
Well, that's definitely peculiar. That reminds me that something that also tends to differ between jurisdiction when it comes to freezing orders is the intervention of third parties and their role in the decision to grant the order. Any thoughts on this?
Yes, indeed, Kiko. Unlike in other jurisdictions, in Spain, only the applicant and the respondent are parties to the order. However, this does not mean that no obligations may be imposed on third parties. For example, banking entities may be ordered to freeze bank accounts of the respondent. These third parties are notified of the order, and fines may even be imposed on them for lack of compliance. No duty of care is due by the third parties to the applicant, so aside from the fines, third parties cannot be held liable.
I find especially relevant that these third parties have no other obligations than those notified to them by the court. For instance, in the case of freezing of bank accounts, the order may only comprise amounts existent in accounts at the time of the order. And while banking entities have an obligation to communicate to the applicant the freezing of the accounts and the frozen amounts, they are only required to freeze only up to the order amounts and only in the order accounts. This means that no further duty of care exists, as Paco was saying, and no further liabilities can be sought against banking entities other than fines for lack of compliance.
Those are really good points, thanks. Now, in a podcast like this one that focuses on cross-border perspective of litigation, I think it is important that we address a few issues at the beginning. In our practice, many times, we seek the help of our colleagues of Evershed Sutherland offices in other jurisdictions for requesting or enforcing freezing orders abroad, which may not always be easy. So, the first thing that I wonder is whether a Spanish court or arbitrator can freeze assets that are located outside of the Spanish territory.
There is no strict answer to a question, Kiko. Generally speaking, Spanish courts are only competent for granting freezing order of assets within the Spanish territory. Freezing order resolutions, however, can be referred to foreign courts for their enforcement in European member states and other countries with which Spain has signed international judicial cooperation treaties.
And I guess the same happens the other way around. I mean, foreign freezing orders can be referred to a Spanish court for their enforcement in Spain. Is that correct?
That's absolutely right, Kiko. Spanish courts can enforce foreign freezing orders in Spain subject to European regulations and to international judicial cooperation treaties signed by Spain with the respective country.
There is a relevant exception in this aspect, if you allow me, Edu. EU Regulation 655/2014 subjects bank accounts in EU member states to freezing orders granted by courts of other member states. This means that through an EU freezing order, a Spanish court may directly freeze a bank account in another member state.
This is a really good point, Paco. And vice versa, another member state court may freeze bank accounts in Spain by means of an European freezing order.
Exactly, that's the idea, yes.
You were saying earlier, Paco, when we were talking about how arbitrators can grant freezing orders in Spain, that the same requisites for the granting of the order by a court apply to them. What are these requisites?
Yes, Kiko. For any kind of interim injunction, the Spanish civil procedure laws set three main requirements: a danger of delay, a likelihood of success on the merits of the case, and a provision of security by the applicant.
I think we probably should explain briefly what these three requirements imply.
Right, Kiko. The danger in the delay refers to the fact that the judge must deem that if the freezing order is not preliminary granted at a certain moment before the final ruling is passed, there is a relevant risk of the final ruling being impossible to enforce.
And this is because there might be a risk of the respondent disposing of the frozen assets to avoid complying with the ruling.
Exactly, Kiko. The likelihood of success on its part on the merits of the case refers to the provisional conclusion of the court that the applicant stands a good chance of winning the case, or that at least their claim is not reckless and unfounded.
This seems like a fair test to avoid granting orders that are requested in a clear abuse of law with the only intent of damaging the respondent party.
And finally, the provision of security refers to the fact that the applicant must provide financial security to cover the potential losses incurred by the respondent arising from the order.
However, there is an additional requisite specific for freezing orders in Spanish law, isn't there?
Yeah, indeed, there is, Kiko. The applicant must justify to the court that other types of injunctions would be less effective and a greater hardship for the respondent than a freezing order.
Well, now that we have made clear what are the relevant tests that a court will apply to a freezing order request for granting it, I think what our listeners are wondering is how to actually obtain a freezing order. What action must be taken and what are the relevant landmarks in the procedure? Let me start by saying that freezing orders in Spain are mainly requested at the same time as the filing of the statement of claim of the underlying procedure.
Yes, Kiko. Freezing orders may only be requested before the filing of the lawsuit if the applicant can satisfy the court of the urgency or necessity of the matter, or after if the application is based on facts and circumstances that justify that it should be made at that time.
So, how is the procedure initiated?
Freezing orders are only granted at the request of the applicant, who must accredit that the requisites for its granting are met. The court will then hear the respondent review the application and specify the form, amount, and time in which the security must be provided.
I believe we should point out that the applicant may request the court for the freezing order to be granted on an expedited ex parte basis, where the court is satisfied that there are reasons of urgency or that holding a hearing to the respondent may jeopardize the success of the order. The respondent may then object, but that will not suspend the freezing order.
That's absolutely right, Paco. Freezing orders granted without hearing the respondent are relatively common in Spanish civil practice. Another issue our listeners will find interesting is that freezing orders may be requested and granted together with other interim injunctions. Often freezing orders are granted together with a freezing order annotation injunction, which provides for disclosure of the existence of the freezing order of a registered asset in the public registries.
Right. My question to you now is, what happens next? Once the court has decided on the granting of the order, and given the applicant has provided security in the form, amount, and time set by the court, what are the next steps?
Well, Kiko, that's pretty much it. Once the applicant provides the security, the court grants the order, the necessary documents are issued and served upon the respondent or third parties, and the orders enters into force.
As simple as that. I guess the next sensible question is, what happens if, once granted, the respondent does not comply with the freezing order?
In that case, Kiko, and whether it is the respondent or a third party who does not comply with the order, the applicant can apply to the court for enforcement and seizure of the frozen assets. If the non-compliance persists, the applicant may inform the court, and after hearing the interested parties, the court may impose periodic coercive fines on the uncooperative persons and entities, as well as for the seizure of other assets.
So, the only consequences of breaching the freezing order are continuous periodic fines until compliance and further orders.
Yes, Kiko. Well, certain actions that go beyond a plain breach may constitute criminal offences. For example, the attempt of the respondent to irregularly dispose of their assets to elude a freezing order may be constitutive of an asset-stripping criminal offence.
That's an important remark, Paco, thanks. I am guessing all these actions and interventions necessarily generate expenses in the parties. Who bears that cost?
They do indeed generate costs, Kiko. Freezing order incidents follow ordinary rules of litigation costs in Spain. Either party must bear their own expenses during the procedure. So, for example, the applicant will have to pay for their lawyer's costs, expert reports, costs incurred by third parties in delivering all documents and data were requested to the suit, among others.
Right. So, following general rules of procedural cost, there is a chance that those costs may be recovered afterwards. Is that correct?
Yeah, Kiko, at least partially recovered. When final judgment is passed, the court will issue an award on cost and will rule whether one of the parties is to reimburse the procedural costs of the other. Normally, the losing party is also ordered to pay the cost of the proceedings. The invoiced amount of some expenses is completely included in the sentence to pay the procedural costs, like expert reports, while other costs are partially included following certain rules, like lawyers' fees.
Thanks, Edu. Procedural costs are always a relevant issue in court litigation. Well, I think we have covered pretty much all the key issues around freezing orders in Spain, at least those that I can think of. I don't know whether you guys, Paco and Edu, may want to add something.
No, Kiko, nothing else on my side. I think we have covered everything our listeners need to know when thinking about requesting or opposing a freezing order in Spain.
Yeah, I think we have given a good overview of the topic. Of course, many more case-specific issues may arise, Kiko, but I think we have covered the basics.
Yes, indeed, Edu and Paco, thanks. I think the best piece of advice that we can give our listeners if they are in the need to request or oppose a freezing order in Spain or elsewhere is to seek professional assistance and contact the Evershed Sutherland office in their jurisdiction. We are a global law firm with 70 offices in 32 countries across the globe that can help you in any situation, particularly if cross-border legal representation or advice is needed.
That's right, Kiko. Our listeners can go to our website, www.evershed-sutherland.com, and contact us or the team in the relevant jurisdiction to help them or refer to the people who can help them.
Yes, indeed. All right. I think that's all. Thanks, everyone, for listening, and goodbye.
Bye. Many thanks for listening.
Goodbye. Thanks.